Good morning. My name is Mark Silver. I've done a long series of continuing legal education programs for various providers in the United States, and then I provided the same programs on YouTube for free for everybody to have access to. One of the things I've also tried to do on this YouTube channel for forensics and mitigation is to answer questions specifically that lawyers have had about evaluations and about how the evaluations are understood. I work, as I've said before, primarily for immigration, criminal, and civil litigation lawyers, trying to explain and humanize the client's issues and cases, their background, psychosocial issues, their judgment, particular harms they may have suffered, and so on. A particularly difficult kind of case that I see, which crosses over between immigration and criminal, and my expertise is as a criminal mitigation expert for immigration defense lawyers, is the Adam Walsh Act issues as it pertains to immigration lawyers' work. And one question that I've repeatedly gotten that I want to address today very briefly is, what are some of the essential errors that I see in RFEs or even denials in these kinds of cases? And I just want to address a few of them very briefly. The first is that in about 2/3 of the cases, 3/4 of the cases, and I'm sure everybody who's listening to this, who immigration defense lawyers who does Adam Walsh Act cases know what they are, and I have a whole program on YouTube on it specifically, so I won't go into the details again. But one of the most crucial issues that we see from the USCIS when they provide answers, that there is an implicit assumption that the person who's being petitioned for, it's almost always a fiance or a wife, will be at some kind of risk, and that there can never be any true safety because of the American citizen's history of criminal conduct against a minor. What's extremely important for the USCIS to understand, and that they don't get, and I've mentioned this in my programs before, is that if this woman is in this relationship with her husband or fiance for 2, 3, 4, 5 years sometimes, and it's healthy, they love one another, there's mutual support and respect, and there's no indication of any problem. But much more importantly, the American who's petitioning for his fiancé or wife has remained stable and secure. He has not had any problems. He goes to the same job every day. He's engaged in his community, perhaps church, temple. He has healthy interpersonal relationships and so on. That structure is what's most important. That structure, the environmental supports, the familiarity with friends and family and so on, that has kept him out of trouble for 5, 10, 15, 20 years, how long ever it's been, is in a sense the most important part of what we would consider in terms of the person's continuing well-being and continuing on that positive track, and also what we consider to be the most important element to ensure that he and his wife or fiance remain in a stable and healthy relationship. In other words, it's the very supports that he has enjoyed until now that make that fiance or wife most safe. Excuse me. I see this a lot, and I have a CLE on criminal mitigation for immigration lawyers where I talk about this with several examples. But I see this with clients, respondents who have repeated DUIs, for example, and they go to immigration court. They have perhaps 2 or 3 children, and they want to stay in the United States, and it's a very high level of proof, exceptional, extremely unusual hardship in a cancellation of removal petition. And the respondent has these multiple arrests. The arrests usually have occurred 5, 10, 15 years before. What's most important for the immigration judge and the TA to understand is that the respondent who is no longer using alcohol for many years, a good part of that is because of the particular supports in the community, interpersonal, and so on. The consistency, the predictability of his environment, of his behaviors, of his thinking, emotional stability, and so on. And if that individual is forced to, let's say, be deported to Mexico, to perhaps a town where alcohol is ubiquitous, AA meetings are not available, he may not have a job, so he may feel very bad about himself, he may go back to drinking. Those are the kinds of triggers that provide high risk for that individual, who will then be unable to provide any meaningful kind of supports to his American children. Similarly, in the Adam Walsh Act cases, what the USCIS, in many of these responses I see, obviously don't understand is that the female fiance or wife who the American is petitioning for is going to be most safe, most secure, where that American has the supports and consistency that has kept him out of trouble for sometimes very, very long periods of time. The second thing that the USCIS don't seem to really get is that although the standard is no risk, to say that there is no risk when there has already been harm done by the American citizen to a minor female is difficult, if not impossible. When paper and pencil tests are administered or utilized in these kinds of cases, and I don't personally rely on them, but they can be helpful. When they're utilized, the scoring is such that you will never yield a no-risk conclusion. In other words, no evaluation will ever come to the conclusion that that person is at no risk of reoffending given the person's history. The reason that these evaluations do not yield a no risk is because of the person's past behaviors, obviously. And the USCIS, I see in their mind, they correlate the no risk based on the person's history to the current relationship that the two people have together, that the American citizen has for his fiancée or wife that he's petitioning for. And that needs to be clarified. The no risk standard, I understand where it comes from because they're obviously trying to be very careful to ensure the safety of the non-American fiancé or wife. But what's important to understand is the particular relationship and the person who is involved in the evaluation. And let me explain. In the cases that come up in Adam Walsh Act, it's almost inevitably a man who's had a past criminal history of an arrest, and sometimes more than one arrest, against a minor female. Of course, he's now petitioning for his fiancée or wife, who's almost always in the United States, to stay here as a lawful permanent resident. But that fiancé or wife does not resemble the victim in the criminal case. The age of the person is different, the personality is different, often the ethnicity is different, the family position of that person is different. In other words, the fiancé or wife who's being petitioned for does no way resemble the victim or the purported victim in the original criminal case. So that the risk to that particular individual is in fact quite possibly no risk. Again, the reason that the tests yield a low risk when someone's, or extremely low risk for some individuals, is because the test is evaluating the person in the context of the person's criminal history, and not specifically with regard to the relationship that he has at this moment or for many years with his wife or fiance. And understanding that relationship is really the core of the Adam Walsh Act evaluation for USCIS. And I can see that that nuanced difference is not fully understood or appreciated by the adjudicators. This leads into another issue, which is that, and I spoke about this in the full CLE I have on this on YouTube and for individual providers, but there are a host of biases and prejudices that the adjudicator clearly has when evaluating these cases. And it's helpful, I think, from seeing USCIS responses to proactively tackle what those biases or prejudices might be, so that there's no guesswork on the part of the adjudicator in trying to evaluate these cases. It's important to understand that, if you have a client with this kind of problem, you've probably met the client many times and the fiance or wife many times. If I get the case referred, I've spoken to the client 2, 3, 4 times before I even evaluate him and the client and the family. I almost always do home visits in these kinds of cases to ensure that the home is, appropriate, obviously. I'll see the client over maybe 2 or 3 days and other family members. The point is that the lawyer and the experts know the client and the family members very, very well. And the USCIS doesn't have that same benefit. And one way to counteract this, and I think many lawyers are very aware of this, is to document. Put as much proof of rehabilitation as possible in terms of the person's everyday life to help ensure and support the reality that this person is now not only completely different from years before from his crime, but that his daily interpersonal relationship with his wife, community, workplace, church, temple, friends and family, and so on, present the picture of someone who is really quite normal in their everyday activities, judgments, decision-making, and so on. What I see is that the USCIS fills in blanks that are perhaps not filled in by the lawyer or by the expert. And they make assumptions that should not be made. And the way to counter this is by proactively, again, filling in blanks and disabusing the adjudicator of biases, disabusing the adjudicator of prejudices and false assumptions that he or she may have. I think those are the major concerns that have come up. Again, this is for the Adam Walsh Act, and what I've tried to address in just a few minutes are the major concerns that the USCIS either have directly noted in RFEs and denials, or that seem to be implicit within what the adjudicator has written about. This really comes from lawyers asking me what I have found to be the major concerns from USCIS responses, and I hope this has been helpful. What I would encourage you is, if you're interested in a larger outline of the evaluation for Adam Walsh Act cases, please see my other YouTube presentation. I have sample reports, although because it's Adam Walsh Act, cases tend to be quite unique. But if you have any questions, please do not hesitate to email me or even call. My information is always in the description, part of the YouTube info, and thank you for listening today.